I'm so pleased to have a few minutes to talk one of my favorite subjects, FOIA, with a true expert in the field, somebody who really knows this stuff backwards and forwards and lives it every day, Ginger McCall. Ginger is an attorney up in Washington, D.C., where she is the Deputy Associate Chief Legal Counsel for FEMA, the Federal Emergency Management Agency. Before that, she served as the statewide public records advocate for the state of Oregon. Really interesting position where not that many states have this, where somebody actually kind of serves as the voice of the public to help facilitate access to public records. And I'll let her introduce herself a little bit more, but I'm very grateful for your generosity in sharing your expertise with us. So thank you, Ginger.
Thank you. Thank you so much for having me. I will point out, because I am required to, that I am speaking in my personal capacity, not representing the government, just representing myself. Any opinions I express are my personal opinions. So I actually started off my career as a lawyer at the Electronic Privacy Information Center, where I started doing Freedom of Information Act requests, or FOIA requests, and FOIA litigation. Most of what I was trying to get document-wise while I was there, since EPIC is focused on privacy, was documents related to surveillance. This was the sort of post 9/11 era, so we were looking at a lot of surveillance programs related to DHS and TSA, trying to get a hold of documents about new technologies and new programs. And one of the things that I worked on when I was there that I think is sort of core to my passion about public records is I had just come out of law school, and I was working on a public records, a FOIA lawsuit related to the body scanners. Now, the body scanners that you see in the airport right now are very different than the ones that were originally rolled out. The ones that were originally rolled out took a much more graphic image of, what essentially was a naked body. It was projected to a screen that was in a back room and was then looked at by a TSA employee and analyzed to see whether or not someone had any sort of anomalous substances or bombs on them. But the reason that the airport body scanners that you see now are very different is actually because of the Freedom of Information Act work that EPIC and other organizations did. So what we found when we asked for the FOIA documents related to the scanners was that the scanners weren't designed to pick up powdered explosives, which were the big threat at the time, that they were very intrusive, that they were designed to potentially save those images. And we were able to leverage that information to force policy changes at the Department of Homeland Security on a national level. We formed a very broad, diverse coalition of different stakeholders, and we actually forced policy change on a national level, and it was only because of those documents that we were able to do that. So, I have seen again and again that public records, often obtained through FOIA requests or lawsuits, do result in national policy change. We got policy changes at the Department of Homeland Security related to its social media monitoring, to license plate readers, to a lot of other surveillance technology. And the only way that we were able to do that was through public records requests and public records litigation. So just a real quick overview of the FOIA. What is the FOIA?
Let me stop you one sec, because I really want to emphasize for the people that are sitting on their couches squirming right now and saying, I'm not going to be an investigative reporter. Why do I need to know this stuff? You just explained so beautifully that, in fact, the vast majority of people who use the Federal Freedom of Information Act are not investigative reporters. It's used quite a lot in things like advocacy for social change, that organizations like EPIC that you work for use FOIA to be able to kind of check on what the government is up to. Yeah. And armed with that knowledge, then you can advocate for change. So you never spend a day in a newsroom in your life, but you still may wind up.
Exactly. And FOIA is used by a vast array of different professions. Historians often make FOIA requests for historical documents related to agency decisions. Something like the Bay of Pigs or, any other major historical event, you can get FOIA documents on that. And in fact, it's easier now than ever to get those documents because there's now a 25-year sunset on one of FOIA's biggest exemptions. So, if you're looking for historical documents, now is a great time to look for them. Folks who are interested in their own family history are often looking for FOIA documents. Researchers, academic researchers at universities on a wide variety of topics. Watchdog groups that might want to know, for instance, what the FDA is regulating and what kinds of regulation the FDA is doing and whether or not it's actually effective, would be looking for FOIA documents. So, there are a wide variety of different users of FOIA, not just reporters. Reporters obviously are the most high profile, but there are lots of different folks who use FOIA.
Yeah. Give us the 101. Yeah. How does this thing work? Why do we have it?
So the FOIA is a very good law. It's not a perfect law, but one of the great things about it is that it actually sets a firm deadline. So anyone can make a FOIA request. You do not have to be a US citizen. You can be anyone in the world and make a FOIA request. A business can make a FOIA request. A law firm can make a FOIA request. An individual can make a FOIA request. If you're 10 years old, you can make a FOIA request. Anyone can make a FOIA request. And then an agency has 20 business days to respond to that request. That's about a calendar month. And if they don't respond in that time, then you have appeal rights, which I'll talk about a little bit more later. I know that you and I were going to chat about that. What are your remedies under the law? Under FOIA, there is a presumption of disclosure. Unless there is an actual legal reason for an agency to withhold the information, they have to give it to you. So, presumption of disclosure, which was embodied in the law, it was a policy for a while, but it was actually made law a few years ago. Which is great because the burden is on the agency to articulate if it's going to withhold information. FOIA also has a fee structure, which is favorable for public interest requesters, especially news media, but also educational requesters and non-commercial scientific organizations. Those requesters only pay the fees that are associated with duplication, which in the modern context is often just $5 for a CD and the mailing price of the CD. Sometimes it's nothing because the agency can send you the documents digitally. If you are a requester who's not in one of those categories, so news media, non-commercial scientific organization, or educational requester, then you pay for search and review costs. That means the time that the agency spends searching and the time it spends reviewing the documents and applying exemptions. Commercial requesters, so commercial law firms or businesses that are making requests for their own self-interested reasons, pay for the duplication costs, the search, and the review fees. But FOIA's fee structure is better than most state fee structures for public records, and it is designed to incentivize requests by public interest requesters. And also to note, since this is for students, that definition of educational requester has been broadened. It used to be that if you were a student receiving credit for a class, you couldn't necessarily qualify as an educational requester to get that reduced fee. But there was a case in the DC Circuit just recently, a couple of years ago, that found that educational requesters, that is students at academic organizations, can qualify for those reduced fees. So, only duplication fees, which is sometimes literally nothing. So I would encourage you, if you have a document set that you are interested, to avail yourself of that. And you want to make sure, if you're requesting that favorable fee status, that you note that in your FOIA request so that the agency knows. So FOIA has fees. Sometimes they're negligible, but they do exist. And FOIA also has 9 exemptions. So the 9 exemptions are, first, for exemption 1, which is national security information. That's your classified information. Pretty easy to figure out what that one is. Exemption 2 is information related solely to internal personnel rules and practices of an agency. That one used to be seen more regularly because courts had very broadly interpreted it. But the Supreme Court in about 2011 decided that they were going to very narrowly interpret that exemption. So now you're not going to see that one in the wild very much. Number 3 is information that's prohibited from disclosure by another federal law. A lot of security-related agencies like the NSA or the CIA or DHS have specific laws that allow them to withhold information. Exemption 4 is trade secrets or commercial or financial information that's confidential or privileged. That one is often seen. If you are looking, for instance, for a government contract, you can get the sort of bottom line amount of that contract, what the government is paying for, but you're probably not going to be able to get a company's hourly rates that they're charging, because that would be considered confidential information that could harm the company competitively. Exemption 5 is for privileged communications. This sweeps in your litigation privileges. So deliberative process, attorney work product, or attorney client. This one is very often seen. Deliberative process especially, that basically protects candor within agencies. This exemption is meant to allow personnel within agencies to have candid discussions about policy. It is not, however, designed to protect the content of actual final policies, but it does allow for the protection of drafts or expression of opinions. So if the agency is talking about potentially instituting some new policy and the employees are sending emails to each other, weighing the costs and benefits of that, those emails would probably be protected as deliberative process. Exemption 6 is information that, if disclosed, would invade another individual's privacy. Exemption 7 is for law enforcement records that could interfere with law enforcement proceedings, compromise confidential witnesses, compromise individual privacy. Any of those things would be exempt under 7. Exemption 8 is for information that concerns supervision of financial institutions. So if you're looking at, for instance, the SEC, you might bump into that. And exemption 9, I have never seen in the wild, geological information concerning wells. So you're probably not going to see that one. The ones that you're most likely to see are exemptions 4, 5, 6, and 7. And if you want more information on these, the US Department of Justice, the Office of Information Policy, has an excellent website that has a whole FOIA manual that will tell you all about when these exemptions apply. And if you're going to make a FOIA request, I would highly recommend that you check that out ahead of time and be familiar with the exemptions, because sometimes if you're familiar with the exemptions, you can craft your request in a way that will be more effective. Like, for instance, the CIA has a very broad Exemption 3 statute that allows it to withhold any information about its activities or organization. But there's an exception to that for Office of the Inspector General reports within the CIA. So I was interested in, this was back in about 2012 or 13, there were reports that the CIA had been involved in domestic spying on Muslims in New York and New Jersey. And I was interested in getting information about that. I'd heard that there was an Office of the Inspector General investigation into it, because the CIA is not supposed to be involved in domestic surveillance. So instead of making a request to the CIA about all of its activities in New York and New Jersey, I instead made a very targeted request to the Office of the Inspector General, and I asked for the Inspector General's report and executive summary on that particular activity. And I was able to get the executive report and some of the investigation and get some very useful information. And I think it was an above the fold front page story in the New York Times. So, taking the time to understand the exemptions beforehand can be very important. It will save you time, potentially money, if you're going to have to pay fees for the agency to search and review documents that you're never going to see. Because they're exempt, and it will get you the documents more quickly. The narrower the request is that you can put forth to the agency, the more quickly you will get the documents. Most agencies have 3 separate queues. There's the simple queue, which is for requests that are for very simple, one document, a couple pages of documents. There is the complex queue, which is you just really don't want to end up in that queue. The complex queue is the worst queue. Often it's years of backlog. Yeah, you don't want that one if you can avoid that. And then there's the expedited queue, which you have to make very specific arguments for why you deserve expedited processing. But if possible, you want to end up in that simple queue. So make a very narrow request. That's my advice as someone who has litigated FOIA requests on both the inside and the outside of government. To the extent that you can do your research ahead of time, figure out exactly what it is you want, where that document is, and then make a request to that specific office for that specific document, you will get a much better outcome. And finally,
by the way, that you shared that example about the CIA, because if anybody was thinking that there are agencies that have to be off limits from FOIA, the first one you would think of is the CIA. But it turns out that, in fact, there are some documents that the FBI or the CIA actually can't withhold, actually are legally compelled to turn over.
Yeah, I mean, usually making a request to the NSA or the CIA is just a fool's errand. You're not gonna get anything out of them, but there are exceptions to that exception. And I would encourage folks to do their research ahead of time. And another important piece of research is looking at the agency's FOIA regulations. Every agency has FOIA regulations in the CFR. And those FOIA regulations tell you where specifically you should send the request, what rights you have, how you can make your argument for a fee reduction, and all the rules of what you have to do. And if you don't abide by those rules, you send your request to the wrong place. It might not be actually considered a request, and then you might not have appeal rights or any of the other rights that attach to FOIA. Right. So that's the sort of 10,000 foot view of FOIA.
So we talked about CIA, FBI, it's possible to get some documents out of them, but there are actually some agencies that are carved out from FOIA, right? If I want to see Chief Justice John Roberts' emails at the Supreme Court, probably out of luck there, right? What is the
Yeah.
scope of who's covered by FOIA?
So FOIA covers the executive branch. It doesn't cover Congress. Congress helpfully exempted itself from the FOIA. It does not cover the judiciary, and it doesn't cover the president himself, but it covers the president's executive agencies. The president has what's called executive privilege, and so FOIA would typically not cover things that actually belong to the president. But all of the executive agencies, with the limitations in the Exemption 3 statutes, of course, but not the judiciary and not the legislative branch.
Right. So when we're talking about executive agencies, for those listening at home, that's the agency that starts with Department of, right?
Exactly.
Department of Homeland Security, Department of Transportation, Department of Education, or FEMA, like your agency.
Exactly.
And
And importantly, FOIA only covers federal agencies. Each state has their own open government law, and you'll have to research that in your state. Some cities and localities even have their own public records laws. So, what you would be looking for in your state is a public records law or an open government law or a transparency law. And that would govern whether or not you can get state or local documents. The FOIA only makes available federal documents.
Yeah. So when we talk about documents, people probably are conjuring up this image of a big stack of papers. But we know that FOIA actually applies to more than that. So what is regarded as within the scope of a record for purposes of a records request?
So it's pretty broad, actually. Any kind of electronic digital record would be considered a FOIA-able record. Pictures, digital pictures, physical photographs. Like I used to work at the US Department of Labor, OSHA does a lot, the Occupational Health and Safety Administration does a lot of investigations in work sites. Oftentimes pictures are part of that. Pictures, both digital and physical, are a document, a record for the purposes of the FOIA. One thing that is not considered a record for the purposes of FOIA are personal documents. So if I have personal cat pictures on my computer at work, that is not a FOIA-able document just because I'm a federal employee. If I take some of my medical bills into work and have them on my work desk at FEMA, that doesn't make them a FOIA record. They are still my personal records. So personal records would not be subject to the FOIA.
Right.
And again, state and local records, not subject to the federal FOIA.
Yeah, right. It would have to be something that in some way is a record of government business, right?
Yes.
So your cat pictures, not so much, but
Yeah.
something that kind of memorializes the activity of the agency itself.
Exactly. Yeah, it has to be related to government business.
Yeah. We talked about the fees and you talked about exemptions. From the standpoint of the requester community, what are some of the common complaints that you hear? There are people who are dissatisfied customers who feel like they don't get everything that they should be entitled to under FOIA. What are some of those common kind of friction points that you may find yourself having to reconcile as the person at the agency that probably has their phone ring?
So delays are the biggest one. Um, you know, Most agency FOIA offices are very much understaffed. There's been a huge uptick in FOIA requests in the last couple of years. There hasn't been a huge uptick in staff. There's also been an explosion of FOIA-able documents because of email, because of digital communications. There are far more FOIA-able documents now than there were 20 or 30 years ago. And the agency offices don't necessarily have e-discovery tools or good search tools that will help them to process those documents in a fast manner. So that, I think, is one of the biggest complaints. And I will note, if you're making a FOIA request, just keep in mind that the government official that you're dealing with who's helping you with that FOIA request is probably doing their best. They're dealing with very limited resources. They are not the person who is the subject matter expert whose emails you're actually asking for. They're not the agency decision maker who made that decision that you want to find out about. They have no stake in it. They're trying to do a job. And they're doing the best that they can with limited resources. So, remember you're dealing with a person and try to be courteous. I find that nice is always the best place to start. And if you have good communication and you're willing to work with that FOIA officer, oftentimes you'll get a better outcome. FOIA officers are tasked with working with requesters to narrow requests. Requesters don't necessarily know always exactly what they're looking for. So the FOIA officers are supposed to work with the person to try to make the request better, clearer, narrower, and get them the documents that they really want. But yeah, I mean, I think the delays are the biggest complaint. The overuse of some of the exemptions, in particular exemptions 4 and 5, that is, again, confidential commercial information and the deliberative process exemption. Those ones are the biggest complaints, I think. I think insufficient searches are sometimes a complaint that people have. You make a request and you feel like the agency's search was not adequate to actually turn up the documents. But yeah, I think those are probably the biggest perennial complaints. And they're all very challenging, right? Because these exemptions were designed to protect legitimate interests. And there are legitimate reasons why an agency would need to or want to withhold documents. And doing that balancing test of trying to figure out what should be withheld and what should be disclosed is always really difficult. So, these are big challenges. They're big challenges.
So we should mention too, because you did such a nice job of explaining the 9 exemptions, that an exemption isn't necessarily an all or nothing proposition, right? If I need a report or a study or a document, and somewhere in that document there happens to be some social security numbers or some personal medical information that I'm not entitled to have, it may not be an all or nothing proposition, right?
Exactly. There's a segregability requirement in the FOIA, and that basically means that agencies have to look at the documents and they have to only exempt the portion of the document that is properly exempt under the law. So, if there are social security numbers, you would want to just exempt those social security numbers, and you would want to give away the rest of the document. So yeah, I think that's important to keep in mind. And also, under the FOIA Improvements Act, now there is a foreseeable harm standard. So for exemption 5, which again is deliberative process, attorney-client, those sort of big overused privileges, agencies now, if they're going to assert that exemption, they have to give a foreseeable harm for why it is that they're withholding those documents. They have to articulate a harm that would come about if they disclose the documents to the requester. So that also makes it not an all or nothing proposition. And some of these exemptions, the privacy exemption in particular, does have a balancing test. So for exemption 6, which is the privacy exemption, the agency is supposed to make a decision about whether or not to disclose the documents based on balancing the public interest in disclosure on one hand versus the privacy interest in withholding on the other. And so you can see that is a little bit flexible. And that's a place too where you as a requester could potentially make an argument for why the document should be disclosed, because there is a heightened public interest in the document that should outweigh that privacy interest.
Yeah, yeah. So could you kind of walk us through the process here? You make a request, you get back some documents, you're dissatisfied with the quality of the response, or maybe you get back nothing at all. What do you do then? What steps do you want?
So the most important first step is research. You want to look at the agency's FOIA regulations and understand what that individual agency's process is. And you want to make sure, A, the document that you're looking for exists, B, that no one else has already gotten that document and put it out in the public realm. You want to understand what the public interest is in that document in case you bump up against one of those public interest exemptions. You want to think about whether or not you can qualify for one of those fee reductions. And then you want to draft your request. And you want to draft that request and you want to send that request to the best office that you can find. So if you are interested in, ICE's detention of children at the border, don't send that request to the Department of Homeland Security, which is ICE's parent agency. Send it to the ICE component directly, to the ICE component email address, preferably, that is listed in ICE's FOIA regulations. Because what happens if you send that request to the main DHS office is it takes a couple of days bouncing around to get from the DHS office to the ICE component office. You want to eliminate those couple of days of delay, ideally. So send it to the component office if you have identified a component office that has those documents. Make your request as detailed as possible. Include background information, because that information is what is going to let that FOIA officer know where they should be looking for the documents. Agencies have millions and millions and millions of pages of records, and FOIA offices don't always know what every single program in the agency is up to. I mean, I don't know what every single program in the agency that I work at is up to. Agencies are huge organizations. So to the extent that you can say, I believe that this document is in this office, I believe that this document is an email by this particular officer of the agency, that would be better. Make as narrow of a request as possible. If you can narrow the request to a certain date range, if you can narrow the request instead of, all emails or all records related to, please never send an all emails or all records related to request. It will take years. You'll be in the dreaded complex queue. If you can say, emails from X date to Y date that were to or from X, Y, and Z officials, and usually you want to look for the higher level officials, the decision makers, because they're the ones you're not going to run into exemption 5 nearly as much deliberative process. You want to go for the high level decision maker agency officials. Limit what you're asking for. You can start small. You can always expand later and put in, later follow-up FOIA requests. But start small, see what you can get, and see if you can get in the simple queue. So you make your request, and then if the agency gets back to you, and let's say that it is withholding information under several exemptions, and it's also denied your request for a fee reduction, which, by the way, you should put that request for a fee reduction. If you're a news media, non-commercial scientific organization or educational requester, put that in that initial request. That's very important. So if the agency denies that request for a fee reduction and also asserts several exemptions, you have appeal rights. Usually you have, I think, 90 days to appeal, but that varies across agencies, which is why it's important to look at the regulations. You have to look at the regulations so you know how long you have to appeal and where your appeal has to be sent, because if you send it to the wrong place, your appeal might be moot. The agency is not legally required to respond to requests or appeals that don't comport with their regulations. So in that appeal, you want to deal with all of the relevant issues. If you're dealing with exemptions and a fee reduction request that's been denied, you get one bite at the apple. Deal with both of those issues in that appeal. And make sure you send the appeal again to the correct address that's listed in the regulations. Now, you can appeal non-responsiveness. If an agency simply doesn't respond to you, you can appeal that. Sometimes that does get things moving a little more quickly than just staying in the queue. You can appeal an inadequate search. You can appeal a denied request for a fee waiver or fee reduction. You can appeal exemptions, withholdings. But you only have a certain number of days to do that, and you got to send it to the right place. And then if you don't get what you want out of the appeal, if you are someone who is empowered to litigate, or you work for an organization that's empowered to litigate, FOIA does have a litigation option. You have to exhaust those administrative remedies, which means you have to file your administrative appeal, like we just talked about, but then you can potentially go to court. And, I have seen some folks go to court as pro se attorneys, just representing themselves. They're not an attorney. They're just a member of the public who really cares about their FOIA request and wants to litigate it. So there is a remedy within the statute that allows folks to go to court if the agency denies their request or does an inadequate search or just doesn't respond. You can potentially go to court. And there is also one more remedy that was invented about 10 years ago. It's the federal corollary to what I was doing in Oregon. There is a Public Records Ombuds Office, the Office of Government Information Services. It's out of the National Archives and Records Administration. You can Google it, OGIS, OGIS, or Office of Government Information Services, and they do mediate public records requests. So if you are having problems with an agency, they will mediate that. They will talk to the agency and try to get things moving on your behalf. And I would also say that if you have submitted a request and you haven't heard anything back from the agency, call the FOIA officer or the FOIA liaison. Their information will be in the agency's FOIA regulations and on their website. And oftentimes you will get a far better outcome if you have good communication with that person than if you just send an email out into the void. So, follow up with communication, be polite, be kind, understand that we're all humans in difficult circumstances. But don't be afraid to advocate for yourself, to try to narrow the request, to follow up if you need to. Those things can help you obtain a much better outcome.
Yeah, and that administrative in-house appeal within the agency. That's relatively uncommon. You come to a state like ours in Florida, you go straight from denial of your request to circuit court potentially with
Yep.
nothing in between. And so the ability to take it higher up the ladder within the agency, and as you point out, the requirement to take it higher up,
Yep.
and the judge is not going to entertain your
Yep.
case if you haven't exhausted that in-house remedy first. That can be advantageous for a requester because it's a more informal process. You don't necessarily need to engage a lawyer to appeal administratively. It's a little bit less intimidating than going into US District Court. So yeah, that's a kind of an advantageous feature of FOIA that is not true of most states.
Exactly. Yeah. I mean, that is, I think, a very good feature of FOIA. And I have often seen, initial determinations overturned in the administrative appeal. So, it is often an effective mechanism. If you're doing that appeal, you want to make sure, again, you deal with all of the arguments that you have. Spend some time doing some research, look at that DOJ FOIA guide. If you're going to be, making arguments about improper use of an exemption, that FOIA guide that the DOJ Office of Information Policy has will be very valuable to you. It will help you potentially make arguments for why the agency initial decision should be overturned.
Well, I want to give you a chance to just kind of finish up with any tips or advice. And in doing so, maybe kind of talk a little bit by closing about why you think this law is important. Why is it important that we have these laws and that they're properly enforced?
Yeah. So, I mean, I think the anecdote that I told about the body scanners, I mean, it is really important for the public to be able to understand what the government is actually up to. I mean, we cannot be informed voters and informed citizens if we don't know what the government is actually doing. So I think that these laws serve to hold the government accountable, to inform the people about what government is up to, and to improve the functioning of government. If you have government programs that are wasteful or are not properly functioning, putting some sunlight on that, having the people actually see what's happening there is a powerful catalyst for change. So I think, I mean, and like I said, I have seen like national policy changes as a result of public records requests. I mean, it can be quite meaningful to make these requests and to bring these documents out into the light. So I think that, again, it helps with the proper functioning of government. It helps to inform us as citizens so that we can make good decisions about what we want our government to be doing on our behalf. And I think the best tip I can give is just the power of following up and having good communication. And actually the good communication, when I talk to people on the government side, good communication is always what I emphasize to them as well. They should be proactively reaching out to the requester, offering to help them narrow their request, but requesters should be proactively reaching out to the FOIA liaison or the FOIA officer to talk to them about how they can narrow the request, how they can work with the agency to try to get things moved more quickly, and to follow up. I mean, I think that is a very powerful mechanism, and you don't have to be, a Washington Post reporter or a Pulitzer Prize winner to be able to use that mechanism. Anyone can use it. So I would highly recommend just being diligent, following up, using good communication.
And the only thing I would add to that wonderful observation is not only do these laws enable us to keep watch over what the government is up to, but also the industries that the government regulates too.
Exactly.
This is often a window into how we find out what some of those powerful industries that are regulated by the DOT or the EPA are doing, because we get to see their records when they interact with the federal government.
Exactly. Yeah, I think that's really important.
Well, Ginger McCall, thank you so much. This has been really enlightening and wonderful to hear from somebody who has been on both sides of FOIA, who has been both on the requester side and on the agency side in dealing with fulfillment. So your perspective is just invaluable, and thanks for being generous with your time.
Thank you so much.